Did you know that when I cross-examine a doctor at trial, I have the ability to ask the doctor hypothetical questions? Would you like to learn why? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Now, I can ask a doctor hypothetical questions. Why? Because we are asserting that certain facts are true, and it will be up to the jury to determine who's right and who's wrong. And if the jury determines that our set of facts that we are claiming is true, now, once I get the doctor to agree or disagree with our set of facts, it can be dramatic. So let me explain. Doctor, I want you to assume the following facts are true. Mrs. Jones went in to see the doctor on this date, and the doctor did X, Y, and Z. Assuming that those facts are true, would you agree that that would be a violation of the standard of care? Yes or no? Doctor, now let me ask you to assume these facts as true. I want you to assume that the following things took place. If, in fact, the doctor did these things and failed to do X, Y, and Z, would you agree that that would be a violation of the standard of care? Yes or no? Now, why is this important? It's important because at the end of the trial, when the jury is now deciding who's right and who's wrong, if they determine that the facts that we are explaining to them are correct, now what I've done is I've had the doctor in his own words explain to the jury why that would be a violation from the standard of care. And that is very, very powerful. That is why it is critical to ask the doctor hypothetical questions. And you may be thinking, wait a second, can't the defense do the same thing for our expert? The answer is yes, they can. But remember, there are times when the plaintiff's expert or the defense expert turns around and does not agree with the hypothetical questions that are being posed. And they may tell you why. Listen, I don't agree with that set of facts. Well, doctor, I'm not asking you whether you agree or disagree. I'm simply asking you to assume that these facts are true. And if, in fact, they are true, would you agree that this would be a departure or a violation of the standard of care? Yes or no? And if the answer is no, if this is at a pretrial testimony deposition, then I will ask the doctor to explain why. However, if this is at trial, I will not give the doctor the opportunity to explain why. Why is that? Because when I'm cross-examining a doctor at trial, I want to ask leading questions that only require a yes or no answer. I want to take the doctor down a path to determine why he's giving testimony, whether he's objective, why he's basing his opinions on certain things. And now, if I ask these critical leading questions and then ask the doctor hypothetical questions, I can usually get the doctor to either admit and agree or disagree with our statement. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on during the litigation process in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you have questions of your own involving your own matter. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski coming to you from New York. Have a wonderful day.